wager of battle was a way to settle a legal argument, but instead of using lawyers and evidence, it used a fight. It was a duel with rules. The winner of the fight was declared the winner of the legal case. This sounds strange to us now. It seems brutal and random, but for people in the Middle Ages, it made perfect sense. They believed God was watching. They thought God would help the person who was right. So the winner didn't win because they were stronger or more skilled. They won because God was on their side. This idea wasn't new. It had old roots in Germanic tribal customs. Long before organized courts, tribes would solve disputes through combat. It was a way to stop feuds from escalating. A controlled fight was better than a war between families. When these tribes, like the Franks and the Normans, created kingdoms, they brought their customs with them. They mixed their old traditions with Roman law and Christian beliefs, and wager of battle became a formal part of the legal system. It was considered a type of ordeal. An ordeal was a physical test to find out the truth. You might have heard of other ordeals, like ordeal by fire, where an accused person had to hold a hot iron bar. If their hand healed cleanly, they were innocent. If it got infected, they were guilty. Or ordeal by water, where a person was thrown into a river. If they sank, they were innocent. If they floated, the water was rejecting them, and they were guilty. Wager of battle was just another kind of ordeal. It was an appeal to a higher power. It was a way to get a clear answer when there was no other way to find one. Think about a serious crime, like murder or treason. What if there were no witnesses? What if it was just one person's word against another's? Today, we would look for forensic evidence. We would analyze motives and opportunities, but in the medieval period, those tools didn't exist. So what could a judge do? If one man said, "You killed my brother," and the other said, "No, I didn't," the court was stuck. The wager of battle provided a solution. The accuser would formally challenge the accused. They would wage battle. If the accused accepted, the court would set a time and place for a fight to the death. This wasn't just a street brawl, it was a deeply serious religious and legal event. The outcome wasn't just about winning a fight, it was a judgment. A verdict delivered by God himself. If the accuser won, the accused was proven guilty. If the accused won, he was proven innocent. The law would then respect this outcome as the final truth. This core belief that God would intervene to ensure justice was what held the whole system together. It turned a simple fight into a sacred trial. It was a physical contest designed to reveal a spiritual truth. And for many centuries, people believed it worked. It was most common in cases where the stakes were high. Land disputes between powerful nobles were often settled this way. Ownership of a castle or a large estate could depend on the outcome of a single combat. It was also used for crimes that carried the death penalty. The logic was simple. If a man was willing to risk his life to prove his claim must be serious. And if he was innocent, God would surely protect him. This combination of personal honor, legal procedure, and religious faith created the unique and often deadly practice of wager of battle. It was a court of last resort, where the only evidence that mattered was courage, and the only judge was God. A wager of battle wasn't a spontaneous fight. It was a slow, formal process with many steps. Everything had to be done just right for the result to be considered legally and spiritually valid. The whole thing started in a courtroom. It began with a formal accusation. An accuser, called the appellant, would stand before the court and make his claim. He would point at the defendant and state the crime. For example, he might say, "John, you are a traitor who conspired against the king." Or, "William, you murdered my father and I can prove it with my body." This last part was key. He was offering his own life as proof then. The defendant had to respond. He would deny the charge. He might say, "You lie. I am a true man, and I will defend myself with my body." At this point, the accuser would often throw down a glove. This was the wager, the physical symbol of the challenge. If the defendant picked up the glove, he accepted the challenge. The battle was on. But the court didn't just step aside. The judges had to approve the duel. Wager of battle was a last resort. If there was strong evidence or reliable witnesses, the court would prefer to use them. A judge might ask, are there any other proofs? Only if the case was truly one person's word against another's would they usually allow the combat to proceed. The court set the rules. They decided the date, the time, and the place. The fight itself took place in a special area called the lists. This was usually a square field, often 60 feet by 60 feet, enclosed by a fence or barrier. The ground was leveled and cleared. The public would gather to watch. This wasn't a secret event. It was a public spectacle, a form of justice being done for all to see. The court officials, including the judge and sometimes the king himself, would be present to oversee the proceedings. Before the fight began, there were important rituals. Both combatants had to swear solemn oaths. They would often place their hands on a Bible or a holy relic like a piece of a saint's bone. The accuser would swear that his cause was just and that the defendant was guilty. The defendant would swear that he was innocent. They would also swear that they had not used any magic or witchcraft to help them win. Lying under such an oath was considered a terrible sin, damning your soul to hell. This added a huge amount of psychological pressure. You weren't just fighting for your life, you were fighting for your eternal salvation. The weapons were also carefully controlled by the court. The goal was to make the fight fair. If the combatants were knights or nobles, the weapons were usually swords, lances, and daggers. They would fight on horseback at first, then on foot if they were unhorsed. For commoners, the weapons were often less glamorous. They might be given simple clubs, shields, or axes. The key thing was that the weapons had to be equal. One man couldn't show up with a sword if the other only had a club. Sometimes the weapons were even made specifically for the duel and inspected by the court-martial. The fight would begin at a signal from the judge. The rules were simple. They fought until one man was killed or until one man gave up. Yelling the word craven was the traditional way to surrender, but surrendering had terrible consequences. It was an admission of guilt. The fight could also end if one combatant was so badly wounded he could no longer fight. The last man standing was the winner, and the consequences were final. If the accuser lost the fight, he was judged to have made a false accusation. He could be fined, imprisoned, or in some cases, executed for perjury. If the defendant lost, he was proven guilty of the original crime. If he was still alive at the end of the fight, he wasn't just let go. He would be taken from the field and immediately executed in the standard way for his crime, usually by hanging. There was no appeal. God had spoken, and the court carried out the sentence. This brutal finality is what made wager of battle so different from a simple duel for honor. It was a complete legal procedure, from accusation to verdict to execution, all contained within a single fight. Not everyone could fight a wager of battle. The law recognized that it would be unfair to force certain people into combat. A powerful knight couldn't challenge an old man to a duel and call it justice, so the system developed exceptions. Women, children, men over a certain age, usually 60, and people with physical disabilities were exempt. Clergymen, like priests and monks, were also forbidden from shedding blood, so they couldn't fight either. So, what happened if one of these people was involved in a legal case that led to a wager of battle? What if a woman accused a man of murdering her husband, or a monastery had a land dispute with a neighboring lord? Because they couldn't fight themselves. This is where the idea of a champion came in. A champion was a person who fought on someone else's behalf. If you were unable or unwilling to fight, you could hire a champion to take your place in the lists. This turned wager of battle from a purely personal test into something more complex. It created a need for professional fighters, men who made a living from their skill with a sword or an axe. These weren't just random brawlers. They were specialists in judicial combat. They knew the rules, the rituals, and the best ways to win within those rules. Finding a good champion was crucial. Your life, your property, or your reputation depended on his performance. Wealthy individuals or institutions, like a rich widow or a powerful abbey, could afford to hire the best champions available. This, of course, created a problem. Did the person with the most money have a better chance at divine justice? It was a contradiction that people at the time were aware of. It seemed to undermine the whole idea that God was controlling the outcome. But the system of champions was a practical solution to a real problem, so it continued. The champion's role was just as serious as that of a principal combatant. He wasn't just a hired sword. He was a legal representative. He had to take the same oaths as the person he was fighting for. He would have to swear on a holy relic that his cause was just. This meant the champion was also putting his soul on the line. If he fought for a liar, he was committing a grave sin. The risks for a champion were also very real. If he lost the fight, he didn't just lose his fee, he faced legal punishment himself. The idea was that by losing, he had tried to subvert justice by fighting for a false cause. A losing champion might have his hand cut off or be hanged. This ensured that champions took their jobs very seriously. They wouldn't just fight for anyone with money. They had to believe, or at least be willing to swear that they believed, in the cause they were defending. Sometimes, whole communities had to find a champion. A town might be in a legal dispute with a baron over taxes or rights. If the dispute ended in a wager of battle, the town would have to select or hire a man to represent all of them. The fate of the entire community could rest on the shoulders of this one fighter. You can imagine the pressure on such a man. The use of champions changed the nature of the duel. With principles, the fight was a raw test of one man's conviction against another's. With champions, it became a more professional, tactical contest. These were experienced fighters who knew what they were doing. The combat might become less about raw fury and more about skill and strategy, but the legal and religious meaning remained the same. The champion wasn't just fighting for his employer, he was acting as a vessel for God's judgment. His victory or defeat was seen as a divine sign, just as if the lord or the widow had fought themselves. The system of champions was a necessary complication, one that allowed wager of battle to function as a legal tool for all members of society, not just for strong and able-bodied men. It was a practical fix, but one that revealed the growing cracks in the foundation of the whole idea. These duels weren't just something from stories, they really happened, and the records of some of them survive, giving us a glimpse into the high-stakes drama of medieval justice. Perhaps the most famous case of all was the last judicial duel, officially sanctioned by the King of France. It took place in Paris in 1386. The story involved two knights who had once been friends, Jean de Carouge and Jacques Legris. Carouge was a soldier, often away at war. Legris was a courtier, popular, and well-regarded. While Carouge was away, his wife, Marguerite, claimed that Jacques Legris had broken into her chateau and violently assaulted her. Legris denied it completely. He had a powerful alibi, supported by several other men. There were no other witnesses to the alleged crime. It was Marguerite's word against Legris's. The Parliament of Paris, the highest court in France, could not determine the truth. After a long trial, Jean de Carouge, convinced of his wife's honesty and his friend's betrayal, demanded a trial by combat. The king, Charles VI, agreed. The duel was a massive public event. Scaffolds were built for the king and his court. A huge crowd gathered. The stakes were impossibly high. If Carouge won, Legris would be proven guilty and his name disgraced. If Carouge lost, he would be killed in the fight, and his wife Marguerite would be burned at the stake for making a false accusation against a nobleman. Her life depended entirely on her husband's ability to win. The two knights, clad in full plate armor, charged each other on horseback. Their lances shattered. They fought with axes, then swords, then daggers. The fight was long and brutal. Both men were wounded. In the end, Carouge managed to wrestle Legris to the ground. With his dagger at Legris's throat, he demanded a confession. Legris cried out, "In the name of God, and on the peril and damnation of my soul, I am innocent." Carouge did not believe him. He drove the dagger home, killing Legris. Carouge was declared the winner. He was hailed as a hero, his wife's honor was restored, and her life was saved. Legris's naked body was dragged through the streets and hung from the public gallows. The court, the king, and the people all accepted the outcome as the judgment of God. But the sheer brutality of the event, and the fact that a noble's life was ended based on a duel, made many people in France question the practice. It was the last duel of its kind there. In England, wager of battle lasted much longer on the law books, even if it was rarely used. Its end came about in a bizarre and almost comical way in 1818. A young woman named Mary Ashford was found drowned in a pit. A man named Abraham Thornton was accused of her murder and rape. He was put on trial with a jury. The evidence was circumstantial and Thornton was acquitted. Mary's brother, William Ashford, was not satisfied. He used an obscure ancient legal process called an appeal of murder to bring a private prosecution against Thornton. This old law allowed a victim's family to accuse a suspect directly, even after a jury had found him not guilty. And this old law came with its old procedures. When Thornton was brought to court again, his lawyer had found a loophole. He declared that his client would not be tried by a jury, but would instead claim his right to wager of battle. He stood in the court, pulled off a leather glove, and threw it to the floor, challenging William Ashford to a duel to the death to prove the charge. The court was stunned. Nobody had done this in centuries. The judges had to consult ancient law books. After months of deliberation, they had to admit that, legally, wager of battle had never been abolished. It was still technically a defendant's right. William Ashford was not a fighter. Thornton was a big, strong man. Ashford declined the challenge. Because Ashford refused to fight, the court had to follow the old rules. Thornton was declared innocent and set free. The public was outraged. It was clear that an ancient law had been used to escape modern justice. The next year, Parliament acted swiftly. They passed a law that formally abolished all forms of trial by ordeal and wager of battle, once and for all. A medieval practice had survived, forgotten in the law books, until a 19th century murder case brought it back to life just long enough for it to be finally killed. The idea of wager of battle faded away slowly. There wasn't a single day when everyone decided it was a bad idea. Instead, it was a long process of changing beliefs about justice, religion, and the role of government. Different forces worked together over centuries to make trial by combat obsolete. One of the most important changes came from the church itself. For a long time, the church had supported ordeals. Priests would bless the hot iron or the water used in the tests. They were present at duels, holding relics, and leading prayers. But by the 12th and 13th centuries, leading thinkers in the church were having second thoughts. They started to question whether it was right to demand a miracle from God to solve a legal problem. It seemed like testing God, which was a sin. In 1215, a major church council, the Fourth Lateran Council, made a decisive ruling. It forbade clergy from taking part in any trial by ordeal. Priests could no longer bless the proceedings. This was a huge blow. It stripped the ordeal of its religious legitimacy. If it wasn't a sacred test approved by the church, it was just a fight. The divine judgment part of it was gone. At the same time, legal systems were becoming more sophisticated. Kings and rulers wanted more control over justice in their lands. A system where nobles could fight each other to settle land disputes was messy and unpredictable. A strong central government wanted a justice system that was reliable and under its own authority. They began to favor courts that worked differently. This led to the rise of what is sometimes called an inquisitorial system of justice. Instead of just presiding over a fight, judges and officials started to actively investigate cases. They looked for evidence, they questioned witnesses, they tried to build a logical case based on facts. In England, the jury system became more and more common. A group of 12 local men would hear the evidence and decide on a verdict. People started to see that this was a more reliable way to get to the truth than watching two men hit each other with swords. A jury might get it wrong, but it seemed a lot less random than a duel. The practical problems with wager of battle also became more obvious. The champion system was a clear issue. When a rich man could hire a professional warrior, it was hard to argue that God was truly deciding the outcome. It looked more like the person with the most money was buying justice. This sense of unfairness eroded public faith in the system. And over time, society's values just changed. As the Middle Ages gave way to the Renaissance, people began to think differently. The world felt a little less magical and a little more rational. The idea of expecting God to personally intervene in every single court case started to seem old-fashioned, even primitive. As justice became something that humans were responsible for using reason and evidence, rather than something they asked God to handle directly. So, wager of battle didn't disappear overnight. It just became less common. People chose other options. Courts offered jury trials or investigations. By the 1400s and 1500s, it was very rare. It remained in the law books in some places, like England, as a strange relic of a bygone era. It was a legal fossil, a memory of a time when the world worked differently. Its final abolition in England in 1819 after the Thornton case was just a footnote, the official closing of a chapter that had, in reality, ended long before. The wager of battle shows us a lot about the medieval mindset. It reveals a world where the line between the physical and the spiritual was blurry. People believed that a fight could reveal a moral truth, and that God was an active participant in the daily lives of humans. The end of this practice marks a major shift in Western thought. It marks the move toward a world where justice is sought not through divine intervention, but through human reason, evidence, and law.